Hello, everyone, and thank you for being here today. My presentation will address the recent developments in Canada's approach to HIV criminalization, as well as the role of the Canadian Coalition to reform HIV criminalization in fostering these changes. My name is Léa Pelletier-Marcotte, and I'm the coordinator of the Human Rights and HIV program at COXIDA in Montreal. I'm here on behalf of my fellow authors. Before we begin, I would like to state that I have no conflicts of interest. What is the Canadian Coalition to Reform HIV Criminalization? The coalition was created by a group of Canadians and representatives of Canadian organizations who met at a HIV criminalization convention held in the US in May 2016. While these people were already, to some extent, already involved in HIV criminalization advocacy work, this event compelled them to join forces at the national level. The objective of the coalition is to progressively reform the discriminatory and unjust criminal as well as public health laws that criminalize and regulate people living with HIV in relation to HIV exposure, transmission, and non-disclosure in Canada. The membership of the coalition is diverse and growing. It includes people living with HIV, community organizations, lawyers, and academics. The coalition is led by a steering committee where a majority of the members are people living with HIV. One of the guiding principles behind the creation of the coalition was to put the lived experience of HIV criminalization forward and to ensure that these individuals and their stories were actively involved when advocating for criminal law reform. So when we talk about HIV criminalization in Canada and the need for a new approach, what exactly do we mean? In a 2012 landmark case, the Supreme Court of Canada ruled that people living with HIV had an obligation to disclose their status to a sexual partner before sex that posed a quote-unquote realistic possibility of transmission of HIV. Failure to disclose before sex that posed a realistic possibility of transmission means that a person could be charged with a serious crime. Nowhere in the criminal code does it say that it's a crime not to disclose. This obligation comes from the way the courts, especially the Supreme Court, have interpreted existing criminal code provisions so that they could apply to cases of alleged HIV non-disclosure. In the last couple of years, aggravated sexual assault has been the charge most commonly laid in cases of HIV non-disclosure, which means that people who are convicted face a maximum sentence of life in prison, as well as mandatory sex offender registration. But what really is a quote-unquote realistic possibility of transmission? Well, it's actually unclear. In its 2012 decision, the Supreme Court said that there is no realistic possibility of transmission and therefore no obligation to disclose if a condom is used and the HIV positive partner has a low viral load or suppressed viral load. But the court also mentioned that this general proposition did not preclude the common law from adapting to changes, including advances in treatment. Nevertheless, following the decision, most Canadian courts, judges, and prosecutors adopted a very narrow and restrictive view of the realistic possibility criteria, stating that both a condom and a low or suppressed viral load were needed to negate the realistic possibility of transmission. This means that a person can be convicted for not disclosing even if they had no intention to cause harm and HIV was not transmitted. This also leads to people being charged, prosecuted, and convicted for not disclosing even in cases where there was little or no risk of transmission. For instance, when a condom was used or when a condom was not used but a person had a suppressed viral load. It goes without saying that this approach is especially severe and of course has led to unfair and discriminatory results. There have been some encouraging developments within provinces, including lower courts, but as well as prosecutors or attorney generals in some provinces taking heed of the science and adjusting their decisions as such, but nothing consistent nor binding on all Canadian courts. So on the whole, Canada's approach remains unfair, discriminatory, and overly punitive. This is where the work of the coalition comes into play. On World AIDS Day in 2016, the Attorney General of Canada recognized the problem of overcriminalization of HIV and said it was committed to studying the issue. In 2017, the coalition therefore engaged with Justice Canada in its study, including by sharing testimonies of lived experience of HIV criminalization. Simultaneously, it worked on the development of its community consensus statement, a statement that is a shared critique of why Canada's approach to HIV criminalization is actually wrong. The statement was released in late November 2017 and is now endorsed by more than 170 organizations across the country. The statement calls for some specific actions that the federal, provincial, and territorial governments should take and must take to end the unjust criminal prosecutions against people living with HIV. These changes include sound prosecutorial guidelines to preclude unjust HIV prosecutions, legislative reform so as to remove HIV non-disclosure from the reach of sexual assault laws, the development of resources to address misinformation, fear, and stigma related to HIV. So a few days after the release of the community consensus statement, Justice Canada released its report on the criminalization of HIV non-disclosure, which reflects to some degree certain limits of HIV criminalization, that were urged by the community. So, encouraged by some of the conclusions within the report, the coalition continued to press for changes at the provincial and federal levels in 2018. One of the things that we asked for, and one that was as well recommended in the Justice Canada report, was the development of prosecutorial guidelines to achieve greater consistency in the application of the criminal law in the country. So we pushed this idea forward in our advocacy that year. On December 1st, 2018, the Federal Attorney General announced an official directive to the Public Prosecution Service of Canada, stating that federal prosecutors shall not prosecute HIV non-disclosure in cases where the person living with HIV has maintained a suppressed viral load, because in these cases, there is no realistic possibility of transmission. The directive also stated that federal prosecutors shall generally not prosecute HIV non-disclosure cases where the person has not maintained a suppressed viral load, but has used condoms or engaged only in oral sex or was taking treatment as prescribed, unless other risk factors are present. Because in these cases, also, there is likely no realistic possibility of transmission. So while this was encouraging and represented a sizable advancement, the directive effectively only applies in the territories, so it's quite limited in scope. It also does not go as far as we would like a directive to go, i.e. to limit criminal law to actual and intentional transmission of HIV. So in April 2019, the Standing Committee on Justice and Human Rights began its long-awaited study on the issue of HIV criminalization. And by this time, the coalition was well established as a key stakeholder on the issue. So many members of the coalition were actually invited to testify before the committee. Having the coalition help the members have a common objective and a common language, while also highlighting their own specific expertise, point of view, and experience. This united front was noted by the Standing Committee, which I believe made our arguments that much more powerful and convincing. In its report, the Standing Committee majority opinion concludes that indeed Canada's approach to HIV criminalization is too broad, overly punitive, and inconsistent with science. It also makes a number of recommendations that, for the most part, resonate with our demands, including removing HIV non-disclosure from the reach of sexual assault laws, ensuring a greater certainty across provinces, and criminal code reform. So in less than 4 years of existence, the coalition has led to a number of advancements thanks to its cohesive community engagement. Now that Canada's approach has been recognized as outdated, discriminatory, unjust, and too harsh, there's still a lot of work ahead to ensure that criminal law is actually reserved for actual criminal conduct. Therefore, on the federal front, criminal code reform is still needed to preclude resorting to sexual assault charges to address alleged HIV non-disclosure and to limit HIV criminalization to actual intentional transmission. In the meantime, on the provincial front, we need to continue asking for more predictability and cohesion as to how the criminal law could apply to people living with HIV across provinces and territories. Finally, coalition members are working towards better supporting people who are or have been incarcerated or charged for alleged HIV non-disclosure. As I'm sure you agree, 2020 is not exactly going as we planned it, but I'm sure the members of the coalition will find a way to make things move along nevertheless. I thank you for your attention and your interest, and do not hesitate to contact the steering committee for more information or for any question that you may have. Thank you.